Hello everyone and welcome to today's Mondac webinar in association with Tan Hassani and Councils, which seeks to provide an introduction to aircraft financing and leasing to Philippine operators. My name is Dan Sampaio and it's my pleasure to introduce you to our wonderful panel. Kerwin Tan graduated from a top law school in Manila and has a diploma in law from Sydney University to practice in New South Wales, Australia. He's been practicing for more than 15 years and focuses on aviation, commercial transactions and tax. Eugene Kaur is a former government official, having served for 9 years in various senior management capacities in the legislative and executive branches of the Philippine government, the most recent of which was as Assistant Secretary in the Tourism Department. He counsels several air operators, appears before the Civil Aviation Authority and assists with applications for air transport services. Beiruta started her career at the Philippine affiliate of Ernst & Young, where she handled contentious tax assessments before moving on to general litigation practice. After a brief stint at the office of the Speaker at the House of Representatives of the Philippine Congress, she is now a member of the firm advising on aviation, commercial transaction, and industrial law and dispute resolution. Now, before I hand you over to the panel, a housekeeping item. You can submit questions to our panel by typing them into the questions pane of the control panel on your right. We will endeavour to answer as many questions as possible. It's now my pleasure to hand you over to Kerwin, Eugene and Faye. Thank you.
Thank you for that, Dan. Thank you for the wonderful introduction. Good morning, everyone. Good morning and good evening to everyone. Thank you for taking the time to be here. My name is Kerwin Tan, and we will try to keep this discussion as interesting and insightful for those who would be interested in leasing aircrafts or engines to the Philippines. There would be 3 general parts of this webinar, which I and my colleagues will be discussing. Next slide, please. So part 1 of this webinar focuses on structuring the deal and the minimum suggested transaction documents. Later on, we will be talking about a significant but often overlooked Philippine legal concept which affects the way an aircraft lessor should approach leasing aircrafts and engines to a Philippine lessee. We will also be discussing transaction documents that would align with the structures that we will be discussing today. Next slide, please. Part 2 of this webinar discusses how an aircraft is to be registered in the Philippines, the formalities and the documentation involved, and how to protect ownership interest for a financed aircraft or an operated aircraft under an operating lease. This would be discussed by my colleague Eugene. We will also segue a bit here on engine registration. Next slide, please. Part 3 of this webinar discusses provisional remedies an owner may take in the event a dispute is ongoing. This would be discussed by my colleague Faye. Normally, the governing law would be either English law or New York law. However, in order to preserve the aircraft while the dispute is ongoing, some provisional remedies may be taken by the aircraft owner while in the Philippines. Next slide, please. So without further delay, I will now start with how to structure the deal and some pitfalls to avoid. Let me start by saying that while this webinar is intended to be for aircraft finance, the topics we will be discussing here applies to both finance aircraft and operating lease aircrafts. In some cases, one transaction may even involve those 2 types of leases at the same time. So this topic is also equally applicable to general aviation and commercial aviation. Next slide, please. So we will start the discussion on structuring by introducing a concept in Philippine corporate law called doing business without a license and its implications. This applies to aircraft lessors or aircraft owners who will be entering into lease agreements with Philippine lessees. The 2 discussion elements here are doing business and license. So doing business is a very broad concept, which starts from merely soliciting business from Philippine lessees and any other act which imply a continuity of commercial dealings in the Philippines. So as you can see from the slide, that is quite a broad concept, the concept of doing business in the Philippines. The High Court of the Philippines has developed tests to determine whether a foreign company, such as an aircraft lessor, is considered doing business in the Philippines. The first is the twin characterization test with two elements. First, the nature of the transaction itself, and second, the intent to continue doing business in the Philippines. So, for example, an aircraft lessor entering into an aircraft lease fits the bill of the first element, which is the nature of the transaction. The continuing intent is easily seen if several deals are originating with Philippine lessees, showing a continuity of commercial dealings in the Philippines. The second test of the doing business is what we call the contract test, which looks at where the contract, such as the aircraft lease, was perfected and consummated. So either or both tests can be used, since no general rule can be laid down as to what constitutes doing or transacting business in the Philippines. So each case must be judged in light of its own peculiar circumstances. So if an aircraft lessor, or any foreign company for that matter, is doing business in the Philippines, does it need a license? Under Philippine law, as a general rule, foreign companies such as aircraft lessors shall have the right to transact business in the Philippines only after it has secured a license to transact business in the Philippines from the Securities and Exchange Commission in the Philippines. So essentially, the word license here refers to registering a company in the Philippines. Now, you might ask yourself, why would I want to go through the trouble of registering a company in the Philippines just because a Philippine lessee approaches me to finance or to lease an aircraft to be operated in the Philippines? Well, the consequences of doing business without a license is that the lessor shall not be allowed to file suit in any Philippine court, but the lessor may be sued in Philippine courts by the Philippine lessee. Next slide, please. So the good news here is that you don't really need to go through registering a company in the Philippines just to enter into a deal like that, because there are some well-recognized exceptions to this rule. And this is where proper structuring of the deal comes in. So let me go through each of these exceptions. So the first exception is the isolated transaction rule. So as the name implies, if this is a one-off lease, then that's an isolated transaction. So it's not considered doing business in the Philippines. The second exception is if the lease is consummated outside the Philippines. Now, normally both parties will sign in counterparts, with the lessor signing outside the Philippines. If the delivery of the aircraft happens also outside the Philippines, this is considered consummated outside of the Philippines. So acceptance of the aircraft usually is done outside the Philippines, where the aircraft is originally located. So this is the second exception to the rule. The third exception is for exports in an aircraft lease. The aircraft is usually exported by the lessor and imported by the Philippine lessee. So the mere act of exporting by the lessor without doing any commercial act in the Philippines is not considered doing business in the Philippines. The fourth exception is that it is quite important that the lessor does not actually transact business within the Philippine territory in its own name. Then that is not considered doing business in the Philippines. The fifth exception is mere ownership of an asset in the Philippines, such as the aircraft, which is to be located in the Philippines, is not considered doing business in the Philippines, so long as the lessor does not actively use or do business in the Philippines, does not actively manage the aircraft in the Philippines. That is not considered doing business in the Philippines. So here, it is the lessee who will actually be using the aircraft in the Philippines. So it is important that the lessor does not use or does not maintain directly by itself the aircraft in the Philippines. But normally in an aircraft transaction anyway, the responsibility of maintaining the aircraft is on the side of the lessee. And the last exception is the Philippine lessee, despite all of these, the Philippine lessee may not invoke the lack of license to avoid the lessee's obligations under a valid lease. This is because part of the doctrine of estoppel dictates that since the lessee has received the benefit of the aircraft lease, then it should not be allowed to invoke the lack of license of the lessor. So equity also plays a role in preventing a lessee from disputing a validly signed contract where it has gained a benefit. Now, having discussed what is the concept of doing business without license and what are the exceptions to this rule, how do we implement all of these exceptions through structuring the deal itself? As we shall next see, these exceptions are not mutually exclusive, and they are meant to be utilized to the full extent per transaction. So here on this slide, on the structuring scenario one applies more to aircraft finance. So in our experience in the Philippines, we have mainly used this to finance business jets. So business jets are mostly one-off transactions per Philippine lessee. So for each aircraft to be financed for each lessee, under this scenario one, the owner or the lessor will require that the lessee should have an offshore company, maybe in the BVI or in the Cayman or even in Hong Kong or Singapore, so long as offshore from the Philippines, it's outside the Philippines. So the head lease will then be outside the Philippines, which is not considered doing business in the Philippines. And eventually, after the finance has been paid off, the bill of sale would then be issued to the lessee's offshore company. So as you can see, this requires several layers for this scenario one to be feasible. So this is a bit cumbersome, though, especially if a lessee would be financing more than one aircraft. This would also be cumbersome for commercial operators who would be doing several operating leases for its fleet. But definitely under scenario one, this is one of the ways to structure the deal in order to take it out from the ambit of what we call the doing business rule. Next slide, please. So now we have scenario two, structuring number two. So here, scenario two applies if the owner lessor or even the lessee requires a direct lease. So compared to scenario one, this is a direct lease from the lessor to the Philippine lessee or the ultimate operator in the Philippines. So the owner lessor can register a company per aircraft to be leased, such that each entity's lease is on a per aircraft basis and therefore may be considered under the first exception to the rule, which is the isolated transaction exception. So because this is per aircraft per transaction, then it can be considered an isolated transaction. So we have experienced a lessor in our practice, we have experienced a lessor with multiple offshore companies, and each company doing an aircraft lease or an engine lease. So each company would have just one aircraft or one engine to be leased. So under scenario two, this could be a direct lease because each would be technically be an isolated transaction. So as you can see, between scenario one and scenario two, proper structuring and on a holistic level, one deal can potentially fall under some or all of the exceptions to the doing business rule. Next slide, please. So I'd like to quickly segue here a bit on taxation, although taxation is more of a lessee side issue. So taxation, insofar as the lessor is concerned, is more of a lessee side issue because most of the lease payments under the aircraft lease agreement would have a provision requiring that the lessor should receive payment in full with no withholding. But just for the benefit of additional knowledge here, for the audience, Philippine lessees are generally required to withhold 7.5% based on the gross rental that they are supposed to have paid to the lessor. So the Philippines follows a withholding tax regime. So because the rent is is a payment on income, Philippine lessees are supposed to withhold 7.5% on the rental payments. So again, this is more of a lessee side issue. The exception here is that if there is a more favorable withholding tax rate under a relevant tax treaty. So the Philippines does have several tax treaties with several countries worldwide. So the advantage to the lease to the lessee under scenario 1 is that both sublessor and sublessee is controlled by the lessee, which is the Philippine company, so that the rent could be studied from a tax efficient angle. So at this point, the lessor is rarely concerned so long as the rent is received in full. So if you compare scenario 1 with scenario 2, next slide, please. Under scenario 2, because this is a direct lease, there is not much room to do a tax study by the lessee. This is only the head lease, which will specify that the rent is payable with no withholding to the lessor. Next slide, please. Now, turning to the topic of the transaction document. So we just described the structure itself. Now we're going to describe the transaction documents that are applicable to this type of structure that we just discussed. So whether it is a finance lease or an operating lease, there would be definitely a head lease. Now, depending on the structure, a lessor may also have to prepare a sublease. In most of the finance lease that we did, there would be some sort of a guarantor, usually either a personal guarantee of the ultimate beneficial owner or a company guarantor affiliated with the ultimate beneficial owner. So the guarantor guarantees that the rental be paid on time. So this is not usual though for operating leases. The guarantor is mostly applicable for finance leases. And since the Philippines is not a party to the Cape Town Convention, it is highly advisable to have a very tight and comprehensive deregistration power of attorney, which should include the authority to represent the lessee with all relevant aviation authorities. Once that we have seen, sent to my team for review, usually requires a lot of tweaking, as the wording we notice is bare bones. Since we are not party to the Cape Town Convention, and thus we do not have the concept of an idea, the deregistration power of attorney should be as comprehensive as possible. Now, aside from all of these transaction documents, we also notice that what is equally or more important is to have the right corporate authorization issued by the Philippine lessee. The lessee's corporate charter or formation document should allow the lessee to enter into the security documents like the guarantors and the deregistration power of attorney. In particular, in Philippine corporate law, Philippine companies generally do not have the power to issue corporate guarantees. So in order to structure the deal properly, some sort of due diligence must also be done on the corporate documentation of the Philippine lessee to ensure that it can validly issue all these transaction documents. So another important piece of documents that all lessors must secure from the lessee is the corporate authorization, such as the board resolution authorizing the lessee to enter into the aircraft lease transaction, and of course to issue the deregistration power of attorney. Without these, the aircraft lease may actually be challenged later on by the lessee in case of a dispute. Lastly, among the transaction documents worth mentioning and tying all of these up on the transaction documents and corporate authorization is the procedural formality in executing all of these documents. So the Philippines is a very formalistic country in the sense that documents are customarily required to be notarized, especially if they are to be filed with any government agency, such as the Civil Aviation Authority. This means that any document signed outside the Philippines would have to be apostilled, or at least consularized in the nearest Philippine consulate in order to be recognized and filed with Philippine government agencies. So the relevance of this formality will now be discussed by Eugene on the next slide.
Thank you very much, Kerwin. Once again, a pleasant good evening and good morning to our audience from all parts of the globe. So this morning, I'll be discussing about aircraft registration and formalities. So it's significant to note and remember that the Philippines is actually an operator registry jurisdiction. So the certificate of registration of the aircraft will be in the name of the operator. So in particular, Philippine civil aviation laws require that an aircraft operator shall only be a Philippine national. So whether it's as a citizen or as a Philippine corporation. So essentially, this is a nationality restriction for our air operators. So while there was a recent amending law removing the citizenship requirement of operators, as of this webinar, however, the implementing rules have not yet been issued. So unless the implementing regulations have already been issued, foreign-owned companies cannot operate aircrafts within the Philippines, subject only to very few cases. So because of this, we suggest that there be additional steps to safeguard the interest of the aircraft owner lessor. Next slide, please. So to apply for an aircraft certificate of registration, the following basic documents must be prepared. So first, the registration application form, of course, is a template form where the basic information of the aircraft is indicated, such as the details on its make and the model, engine details, manufacturer, and the like. So the cover letter is the official request by the operator to the aviation authority to register the aircraft. So the applicant now would have to submit that cover letter as well. This has no template, but is more of a formality to tie together all the supporting documents submitted. So the third document would be the specific registration mark, which must be reserved. And in the Philippines, that would be an RP-C, okay, or RPC. So fourth, the photograph must also include the RPC that is already on the aircraft. And fifth requirement would be the deregistration confirmation that must be directly received by the aviation authority. Number six in that list would be the documentary evidence now of ownership or the lease agreement. Item 7 would be that the aircraft will have to clear customs also. So in some cases, an air operator may have some value-added tax exemptions as an air operator, but this exemption must be applied for separately. Also, it requires a lead time of at least 3 months so that you can apply for that exemption. And also, the corporate documents pertain to the company registration documents of the lessee. And lastly, the corporate authorizations refer to what Kerwin mentioned earlier. The aviation authority will also ensure that there is evidence that the Philippine lessee was authorized to execute the transaction documents and apply with the aviation authority. So some of these documents, as what was already mentioned, the Philippines being a formalistic jurisdiction, it must be notarized, such as the registration application form and the lease agreement. And if it is signed outside the Philippines, it must be apostilled. This is one example of when we say that the Philippines is formalistic, as demonstrated by government agencies requiring apostille if the documents are signed outside the Philippines. Given that these registration requirements add to the time and cost component of closing the transaction, it's all the more important to have knowledge about these procedural requirements so that the parties can prepare ahead of time. Next slide, please. So for better visualization, here is an example of a certificate of registration. So we can look at the different parts of the certificate of registration. So the first there, you would see the registration number. So for Philippine civil aviation aircrafts, that would be an RP-C followed by the number. Second is the make and the model of the aircraft. And the third is the aircraft serial number. Fourth, if you would all notice, the aircraft operator. So the aviation authority will underline either the word owner or the lessee depending on the supporting documents. So usually an owner would present a bill of sale while a lessee would present a lease agreement. And fifth is the date of issue. Now, just below item 7 is the word remarks. And here is where the annotations are indicated. So if there are annotations, then there would be additional pages attached to the certificate. This notifies the reader that there is another page. Next slide, please. As what was mentioned, because the Philippines is not part of the Cape Town Convention, annotations therefore are very important. It is in the annotations where one can see who is the owner of the aircraft and the name of the aircraft owner or lessor. So normally the lease agreement is annotated on the certificate of registration. This means that during the application for registration, the applicant would also apply for the annotation of the aircraft lease agreement on the certificate of registration. So there will be some wordings where the name of the aircraft owner or lessor is disclosed and written down on the attachment to the certificate of registration. So again, because the Philippines is an operator registry, only the aircraft operator can be issued the certificate of registration. But it is in the annotation of such certificate of registration where the identity of the aircraft owner or lessor is disclosed. This gives notice to the third parties that the ownership is not the operator. Another important document to annotate is the deregistration power of attorney or the DPOA, because again, we do not have the irrevocable deregistration and export request authorization or the IDERA in the Philippines. This gives notice to the Philippine Aviation Authority of certain rights and powers of the aircraft owner. So it is by and through the annotations that the ownership of the owner's or lessor's interest is protected. Next slide, please. The last topic that I'll be discussing before I hand you over to my colleague Faye is about engine registration. Through the Philippine Aviation Authority, you can separately register the engine. Do you need to do it? It depends. So once you register the aircraft at the start, the serial numbers of the engine comes with such registration. So you don't really need to have a separate engine registration. But if you install a new engine, then you have the option of having a separate engine registration from the aircraft. And you can have annotations specific to the engine as well. So with that, I turn you over now to my colleague Faye, who will discuss for all of us the remedies in case of breach.
Okay, thank you, Eugene. Okay, so in entering to lease contracts, lessors always have to ensure that remedies are available to them in case of breach by the lessee, especially when, as in this case, the object of the contract is located in another jurisdiction. So the ideal situation is that in case of dispute between the parties, the lessee will voluntarily relinquish possession of the aircraft. If not, the lessor may have to go through the courts to pursue its claim and forcibly take possession of the aircraft. Finance lease and operating lease contracts are usually governed by UK and US laws and not Philippine laws. This is because the lessors are usually situated in those jurisdictions. Hence, in almost all cases, legal actions are initiated and prosecuted outside of the Philippines. But as a matter of business decision, the lessor may also file a case against the lessee here in the Philippines, subject to the concept of doing business, as discussed earlier. In either situation, it is understandable that the lessors would want to recover possession of the aircraft during the pendency of the case, in order to avoid any damage or further use by the lessee who is already in breach of his contractual obligations. So the lessor or the owner of the aircraft may file an original action for Replevin if the case is initiated outside the Philippines, an action for recognition of foreign judgment with application for Replevin if the case is filed and has been decided outside of the Philippines, And third is the usual civil case for breach of contract before the Philippine courts with an application for Replevin. The common denominator in all of these actions is a remedy called Replevin. Next slide, please. The term Replevin is popularly understood as the return to or the recovery by a person of goods or chattels claimed to be wrongfully taken or detained upon the person's giving a security to try the matter in court with a commitment to return the goods if defeated in the action. Next slide, please. So under the rules of Court of the Philippines, in order to initiate an action for Replevin, it must be supported by first an affidavit, which would show that the lessor is the owner of the property or that he is entitled to possession of the aircraft. There must be a description of the aircraft. Second is that the affidavit should state why the property is wrongfully detained according to the best of the knowledge, information, and belief of the lessor or the owner. Third is that the property has not been distrained, taken for a tax assessment or a fine, seized under a writ of execution or preliminary attachment, or otherwise placed under custodia lehis. In simple terms, there is no other legal impediment for the delivery of the aircraft to the lessor. And the affidavit should also state the actual market value of the property. The second requirement in applying for an action for Replevin is the posting of a bond in an amount equivalent to double the value of the aircraft. So the amount of the bond is intended to cover losses which the lessee may suffer should it later be determined that it is the rightful possessor of the aircraft. So once the affidavit is filed and the bond is approved by the court will issue an order and a writ of seizure requiring the sheriff to take the aircraft into his custody. If there is no objection to the bond, the sheriff will deliver the aircraft to the lessor. So it is at this point that the lessor should make preparations for the redelivery of the aircraft to it, whether by leasing a hangar in the Philippines or flying the aircraft to its jurisdiction, subject to proper clearances and determination of airworthiness. If the case is filed outside of the Philippines and a final judgment has been rendered, next slide, please. Okay, if the case is filed outside of the Philippines and a final judgment has been rendered, finding the lessee to have been in breach, the lessor may file an action for recognition of foreign judgment in the Philippines. Under this recourse, the lessor will need to prove the following. First is that there has been a full and fair hearing before the court, which rendered the judgment or the order. Second is that the justice was rendered impartially. There is nothing to indicate either prejudice in the court, which rendered the judgment, or in the system of laws of the country. And lastly is that there is no fraud in procuring judgment. Be that as it may, if it is clearly shown that the lessee had also been a party to and actually participated in the proceedings in the foreign court, he is bound by the judgment. It is important to note that in this case, there will be no trial on the merits. That this is because foreign judgments in the Philippines enjoy a presumption of validity, and the party who seeks to challenge such foreign judgment has the burden of overcoming that presumption. In fact, the rules of court limits the grounds to question the validity of foreign judgment only to the following grounds: lack of jurisdiction, lack of notice to the party, collusion, fraud, or clear mistake of fact or law. Next slide, please. Okay. So before I end our presentation, I'll briefly discuss one very important point which should be considered in structuring your lease agreements. In pursuing the remedies which I just discussed, the lessor will certainly incur costs that may include filing fees, bonds, and even logistics expenses for the recovery of the aircraft. So it is very prudent to include in the lease contract clear provisions that will allow the lessor to reimburse legal fees and costs from the lessee should cases be initiated on account of the lessee's action or inaction. So that brings us to the end of our presentation. I'll turn you over to Dan.
Thank you very much, Faye, and thank you to Cohen, Eugene as well for that fantastic presentation. We really appreciate your time and your efforts putting that together. So I think that we have a bit of time now for questions. So I do encourage our audience to please send in a few questions. For us, it's a fantastic opportunity, obviously, to have those questions answered by our expert panel. I want to draw your attention firstly to this question that we've had in from Keith. Do financiers tend to seek local law mortgages in the Philippines, and has a local law mortgage successfully been enforced?
Okay, I'll let Faye answer that.
Dan, sorry, can you repeat the question?
I can. Do financiers tend to seek local law mortgages in the Philippines, and has a local law mortgage successfully been enforced?
Okay, so under our credit transactions in our obligations and contracts in our civil code, there is the concept of mortgage. However, here in the Philippines, you cannot mortgage a property that you do not own. So if we opt to use mortgage as a remedy, the title of the aircraft has to be transferred to the lessee at the very beginning of the transaction. So as to the lessor, that would be a very a difficult situation, because you will lose ownership of the aircraft even if the transaction is still at its infancy.
So to add to Faye's comment there, so we don't usually suggest to use the mortgage, because that presupposes that the aircraft lessor already lost ownership over or title to the aircraft. It meaning ownership has already transferred to the lessee. So that's a totally different structure altogether. So the ones we're discussing right now is a lease. So the ownership is still maintained with the lessor, owner lessor. So, but if you do go for a mortgage structure, it means that you have already transferred ownership of the aircraft to the lessee, supposed lessee. So, in that case, it would be harder to retrieve the aircraft in case the lessee should default on the payment, on the rent. So we don't really suggest using a mortgage as a sort of a security interest over the aircraft.
Excellent. Thank you very much for that. Another question that we've had in: are there any government incentives or support programs available for aircraft leasing in the Philippines?
Okay, thank you for that question. Very good question. Now, the answer is yes, but it is more of a lessee side incentives. In the Philippines, an air operator is granted VAT, or value added tax exemption, on the importation of the aircraft. VAT in the Philippines is 12%, so that is quite a substantial amount in considering the value of an aircraft. So it is more of an air operator side incentive when they need to import the aircraft for operating within the Philippine territory. Another type of incentive, but this is more related to aviation in general and not to aircraft leasing in particular, is that in the Philippines we do have tax incentives for MROs. The one of the biggest MRO in the Philippines is from Lufthansa Technique, which operates a really big MRO facility in the Philippines. So MROs such as like maintenance, repair, overhaul facilities that operate in the Philippines are granted tax incentives and even income tax holidays for several years. Another type of incentive, but again, it's more for the operator, is that the Philippines has several regional airports that are located within free port zones. So if you're located within a free port zone as an air operator, then you are entitled to VAT exemptions on importation of the aircraft, or income tax holiday for several years based on your revenue. So yes, there is government incentives for aviation and for aircraft leasing, but this is more for lessee operator side.
Brilliant. Thank you for that, Kerwin. Evie asks, please will you clarify, does the foreign judgment have to be full and final, or just full and fair and not appealed?
Faye?
It has to be final. There is a requirement in our jurisprudence, in our case law. Our High Court has held that in cases of recognition of foreign judgment, the foreign decision should be final. But that is a proof, that is a matter of fact. But as to the other matters that should be proved, that there should also have the trial was full and fair. That parties are given opportunity to participate also in the trial in the foreign court. But the requirement that it is final is one of the prerequisites for recognition of foreign judgment.
Brilliant. Thank you very much for that. We still have plenty of time, so if you do have a question, please do send it in. We've had a question here which I think is fairly interesting. Are there any special programs or initiatives aimed at promoting sustainable and environmentally friendly aircraft leasing?
There is none at the moment in the Philippines. It's related to also what I mentioned earlier about if there are any particular incentives. This is more for the lessee side, but for special programs for sustainable and environmental friendly practices, unfortunately, there is none at the moment for the Philippines, at least.
Excellent. Thank you, Kerwin. Just so to follow up on Evie's question, she sent a second part and said, of course, thank you for answering the question. Do you recognize arbitration awards as full and final?
Under our laws, the foreign recognition, it should be a judgment by the court.
Excellent. Thank you very much. And Evie, we do encourage you and everybody in our audience today, if there's anything that you want clarified or to speak to the panel in a bit more detail, please do get in touch. We will be sending contact information over once the webinar has finished, so you'll be able to reach out and speak. Jose has sent in a question. Airlines are granted special tax status under their charters. Are these valid and effective in shifting the tax burden under a lease?
Okay, so in the Philippines, there are two types of air operators. The first is what we generally known as the airlines. So the airlines have what we call their charter is directly from the Philippine Congress itself, what we call a legislative franchise or a special permit directly from the Philippine Congress. The other type of air operator do not have that legislative franchise, but they are granted a license to operate as an air operator, but not to the level of an airline, so to speak. In the Philippines, those that are granted legislative franchise, the airlines that are granted that, they do not have that much of a special tax status. They do have, for example, incentives such as importing VAT-free the aircraft to be used for their operation in the Philippines. But aside from that, for example, they do not have, like, for example, income tax holidays, or they do not have that sort of thing. So these are not effectively, so to speak, these are not effectively shifted under the lease. Because, for example, for VAT, if they import it VAT-free in the Philippines, the importation is actually more of a lessee obligation in the first place. So there is nothing that normally can be shifted to, let's say, the lessor or to the riding public. So there's not much of an effective shifting of tax burden.
Brilliant. Thank you very much for that, Kerwin, and thank you for your question, Jose, and to everybody that sent in a question today. We've got another one in from Evelyn, who sets up a scenario. If one, the borrower is the owner and operator of the aircraft and Filipino company. Two, the lender is an offshore financier. And three, the aircraft is based in the Philippines. In this case, the borrower should grant an aircraft mortgage. Should that aircraft mortgage be governed by foreign law or local law? Is foreign law mortgage enforceable in the Philippines?
Okay.
You should be able to see, Cohen, Eugene, and Faye, that question if if you want to read it out.
Yeah. We're just looking at the scenario right now. Yeah.
Excellent.
Okay. So in the Philippines, we are a civil law country. So generally we follow as our baseline law is what we call a civil code. So in our civil code, parties are generally free to stipulate, terms and conditions so long as they're not contrary to law, they're not contrary to public policy, or not contrary to morals and public order. So parties, the choice of law is actually recognized in the Philippines. It's actually recognized in the Philippines. So there are two elements to the question that I see here. So if the mortgage is governed by a foreign law, that is allowed under our civil law. Choice of law is recognized in the Philippines, similar to an aircraft lease being governed by by New York law or UK law. It's the same. So they can be governed by foreign law. Now the question here really is if not the lessee, because this is a mortgage. So if the borrower defaults on the loan, so there are two elements in the mortgage, right? The first is the loan, the principal agreement itself, which is the loan. The mortgage is what we call, at least in the Philippines, what we call an access. It's merely an accessory to the principal obligation, which is the loan. So the loan itself can be governed by foreign law. So it's a loan agreement. It can be governed by foreign law. So now, whether the question is if there is a default under that principal obligation, which is the loan agreement, then it can be governed by foreign law. And if the venue of action is also, let's say, in New York or in the UK, then that goes to what Faye mentioned, like you have to have a final court judgment and then have it enforced in the Philippines, so that the mortgage, which is the accessory contract, the security contract to the principal obligation, which is the loan, can be then enforced in the Philippines.
Brilliant. Thank you, Cohen. Evelyn asks another question as well. In the corporate jet transactions, is it common to adopt a finance lease transaction, i.e. the financier is the legal owner of the aircraft, or a mortgage loan transaction, so a financier obtains a mortgage to secure a loan advance to a local borrower?
Okay, we have done a lot of corporate jet transactions for more than a decade now. So we handle a lot of from the small turboprops to helicopters to the business jets, and these are the ones that we've handled for more than a decade have all been finance lease transactions. Not one was a mortgage or a loan transaction, because again, we don't see the benefit of a mortgage loan from the side of the owner of the aircraft or the lessor of the aircraft, because you are effectively transferring ownership over the asset without being paid yet. Yes, you can do that, but from a more safety standpoint, we normally do a finance lease rather than a mortgage loan transaction, especially for corporate jets.
Brilliant. Thank you for that great question, Evelyn, and thank you for answering it, Kerwin. What I usually like to do at the end of these webinars is just to ask our panel of experts their key takeaways from the webinar, what you'd like our audience to leave today with. Kerwin, if I could begin with you, and then we'll move to Eugene and Faye as well to get your key takeaways.
Okay. Well, the one thing that we want to impart for this webinar is that there are several structures to doing the deal in the Philippines. This is especially shown by the number of questions that have been asked, like, should we do a finance lease? Should we do an operating lease? Should we do a mortgage loan transaction? So the key takeaway here is that, yes, there are different structures to a deal in the Philippines, but it is very important to identify what your goals are before you even start to enter into any transaction. Because once you identify the structure that you want to do based on what we discussed so far about the different kind of structure that's available, then the transaction documents will follow the structure that was chosen. So it's very important to know the pros and the cons of each type of structure that's available for an aircraft transaction.
Brilliant. Thank you, Cohen. Eugene.
If there's one thing that I would like to highlight, though, is the fact that the best approach is really be a financing lease scenario. Because again, if you go by way of a mortgage, it would be more difficult for the lender to be able to recover as seamlessly as possible the aircraft in case of a breach. So that's why it's very important to highlight also from the discussion earlier that there's a way by which that lease agreement can be annotated in the certificate of registration, and that would very well serve for the protection of the lender or the lessor. Thank you.
Thank you, Eugene. And Faye, if we move to you last, please.
Yeah, so what I would want the attendees to the main takeaway of my discussion is that in case of breach, there would be really costs on the end of both parties. So it would really be prudent to consider the costs, the filing fees, and then the bonds and other expenses for whether it be for arbitration, whether it be for filing cases. The cost of these should be incorporated in our lease agreements in order to further protect the interests of the lessor.
Brilliant. Thank you very much. I think that that's all the questions that we've had in from the audience. So I think that we will be able to finish a few minutes early. But once again, thank you so much to our panel, to Faye, Cohen and Eugene, for your expertise and your insights today. We really appreciate you being with us and sharing those insights with us. It was a really fascinating discussion. And of course, for answering all of the questions that we've had in from our audience. And thank you to our audience for your presence here today and for those questions that you've sent in. As I mentioned, please do get in touch with the panel if you have any further questions. We will be sending the contact information over to you once the webinar is finished. But thank you again for being with us today. Thank you to our panel. I hope you have a lovely rest of your day. Goodbye.